Good morning. Welcome to the Courtroom Files Live. Happy almost Friday. Let's start today out with Judge Simpson. He has a very packed courtroom this morning.
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
You are not. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes.
Court has been provided and has reviewed Michigan Department of State Police report for their case number 1957-23. Any objections to the court having reviewed that report?
No, Your Honor.
None from defense, Judge.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule, and would it be proper to accept this defendant's plea?
People are satisfied.
Defense is satisfied, Judge.
Court will accept the defendant's plea to count 2 in the case ending in 628, and count 1 in that case is dismissed, as well as the case ending in 014. That case is dismissed. This is a victim's rights case, so.
It is, Your Honor.
Pre-sentence investigation and report is ordered at 14A probation. Sentencing in this matter will be
June 11th at 9 a.m.
June 11th, 2025, 9 a.m. before me. Bond will continue in this matter. Okay?
Thank you, Your Honor.
Thank you, Ms. Liu.
Thank you, Your Honor.
Okay, so on June 11th, what's gonna happen? I'm coming back.
Yes, you'll come back and I'll impose sentence. I can't do it today because the victim has to be contacted in case. And so I otherwise I would sentence you today. But yeah, you'll come back on the 11th.
All right, Your Honor, thank you.
All right, thank you.
I'll talk to you before then, Ms. Liu.
Okay.
Court calls the case of the People versus Jacob Dorston.
Michael Gaddy, Assistant Public Defender, on behalf of Mr. Dorston, who is making his way to the podium, Your Honor.
Your name, sir?
Jacob Dorston.
All right, what are we doing on this case?
Your Honor, Mr. Dorston would like to set this matter for preliminary examination. We have had discussions with the people, but he'd like to set this matter. Discovery is complete to the best of our knowledge.
So he's not requesting the adjournment on the,
Oh, no, Your Honor, that's my fault.
well, no, that was from last time. I'm sorry.
Oh,
All right. So all discovery is complete.
yes, Judge.
People have their witnesses available the 27th.
I believe so. The
Preliminary examination in person, May 27th, 2025, 9 a.m. That's before Judge Freshour.
Thank you, Judge.
Bond will continue. I need that.
10 o'clock.
27th, before Judge Freshour. Bond continue.
Thank you, Your Honor.
Thank you. Court calls the case of the People versus Kennedy Braddock.
David I. Goldstein appearing on behalf of the defendant.
Kennedy Braddock.
All right, thank you.
That wasn't me.
I know.
This time.
This time. All right.
Your Honor, we've executed a waiver form. We're going to be waiving exam seeking resolution in circuit court.
Is that correct, ma'am?
Yeah.
You understand the preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yeah.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yeah.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on both counts.
Your Honor, we acknowledge receipt of information in this matter. My client waives further reading, stands mute, asks that a not guilty plea be entered.
Defendant having waived former reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
July 9th at 1:30 p.m. with Judge Conlon.
July 9th, 2025, 1:30, Judge Conlon.
Thank you, Your Honor.
Thank you. Bond will continue. So that's a count. Court does call the case of the people versus Anthony Flanagan.
Joseph and Gollum at the people.
David I. Goldstein appearing on behalf of the defendant.
Your name, sir?
Anthony Flanagan.
Thank you. What are we doing?
Your Honor, as the court is well aware, there was a competency evaluation done in this matter. We are now going to be asking for an evaluation on criminal responsibility, but we'll do that in circuit court. So we're going to waive exam.
Okay. All right. Is that correct, sir, that you're waiving your right to a preliminary examination?
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes.
All right. You understand that you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes.
People also waive their right?
We do, Your Honor.
7, 3, 6.
Your Honor, we acknowledge.
Preliminary examination having been waived, defendant is bound over to circuit court on counts 1 through 5 with 6 following. Go ahead, Mr. Wilson.
Your Honor, we acknowledge receipt of the information in this matter. We waive its further reading. My client stands mute, asked that a not guilty plea be entered.
Defendant having waived formal reading, standing mute to all 6 counts. Court will enter a not guilty plea. Pre-trial will be set for
June 3rd at 1:30 p.m. with Judge Combs.
June 3rd, 2025, 1:30, Judge Combs.
You're all set.
Bond continued. Thank you. Court does call the case. People versus Corey Craig.
Come in. Okay, I thought he was out in the hallway.
Alexander.
David I. Goldstein appearing on behalf of the defendant.
Your name, sir?
Corey Craig.
All right. What are we doing?
Your Honor, I was prepared to ask the court for an exam date, but I was informed this morning when I got here that there may be some media that has not been provided as of yet.
And that's correct, Your Honor. I did put in a request for media discovery yesterday as well for the 911 call. I have not received that.
All right. And we're saying would you be available on 29th?
Oh, I'm looking at the 27th for some reason. Yes, Your Honor.
All right. Probable cause conference will be adjourned May 29th, 2025, 9 a.m. Bond will continue.
Thank you.
Thank you.
Court does call the case of the people versus Haley Gregg. Oh, boy.
Good morning, Your Honor. It's great to see you. Christina Costantino appearing with and on behalf of Haley Gregg. Correct?
You're over there. Your name is?
Haley Gregg.
All right.
Judge, this is a date and time set for a PCC, and we have reached a resolution in this matter. I do have a plea agreement if I could present that to the court. Thank you.
Okay, so how am I going to accomplish this?
Do you mean because it's a no contest plea? Or
Yeah. And I don't have a report.
I do have a clean copy of the report if I could also present that to the court.
So I'm supposed to read that now.
I know, Judge, I apologize.
Okay, the plea agreement indicates that she's going to be pleading no contest to the charge. The maximum penalties on here either.
That would be my fault.
Judge, if I could, the maximum possible penalty is 1 year.
Maximum fine.
That one's a good question, Judge.
It's $1,000.
That it was. 1,000 on the attempt? Yep, we're rolling along in this.
Sorry, Judge. I had to come along
Home. And
and mess
I would
everything
blame
up.
both of them all day for this.
So
Not you.
sorry.
You're good. This is not your fault at all.
No, it's not.
I am looking at the attorneys that don't seem to be ready.
Very sorry, Judge. Very sorry.
What's the maximum? Well, hang on, folks. The maximum penalty on this is going to be. Well. Give me the max on unlawful use and just cut it in half.
My understanding, the max on unlawful use is 1,500.
It's
However,
1,500.
It says if the case is a first offense, the court may reduce the punishment for imprisonment or the fine of not more than $500. So the maximum would be 1,500. The court could, of course.
On the
do more.
principal charge, it would be
Yes.
1,500, which means on this attempt, it's 750.
That would be
All right.
my understanding. My math is not great, but it seems right.
Has she signed an advice of rights form?
Oh, goodness. Judge, I'm sorry.
But let's see. We called one case of Constantino's, and I could have done like 8 cases.
I know, Judge, I'm so sorry.
No, it's okay.
You decide here.
I
It's
have
hard to get the
I have no
signature when they're in
waiting.
custody.
problem waiting. I don't think the rest of these people have that same feeling.
I understand. I apologize to all of my colleagues. I need you to sign this as well.
I'm so nervous.
I need you to sign there too. Sign.
Heather? Okay. All right. Are we finally ready?
I think so, Judge.
Yeah, let's see. May I have her sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Haley Gregg.
All right. Ma'am, it is this court's understanding that you are going to be pleading no contest to the charge of attempted unlawful use of a motor vehicle. That is a misdemeanor punishable by up to 1 year incarceration and a $750 fine plus court costs. You understand that?
Yes, I do.
All right. Do you understand what a no contest plea is?
Yes, I do.
All right, 2 things about it. I have to make sure that you understand it. First of all, means that you're not further desirous or wanting to contest this charge. Hear me?
Yeah, I can hear everybody else.
Okay. You understand that it means that you're not willing or wanting to contest this charge.
Yes, I do.
All right. Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that? You understand also that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court.
Yes, I do, Your Honor.
All right. Now understand, and the basis for the no contest plea.
Potential civil liability.
All right. Understanding all of that, do you still wish to plead no contest?
Yes, I do, Your Honor.
And to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes, I am.
All right. You signed an advice of rights form, is that correct?
Right.
Any question regarding any of those rights? You'll see a copy on the podium. Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up, pleading no contest, you're giving up those rights as well as all the rights on that form.
Yeah. Yeah.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you?
No.
to plea? Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes.
of your own free will?
Yeah.
And because you believe that you are indeed guilty, or I won't ask you that, never mind. Court has been provided Ann Arbor Police Department report for their case number 25-17-355. Any objection to the court reviewing that report to form the factual basis?
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt to the defense counsel. Have I complied with the court?
You have, Judge.
Yes, sir.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court. Probation sentencing in this matter will be
June 6th at 10 a.m. with Judge Perry.
June 6, 2025, 10 a.m. before Judge Perry.
Thank you, Your Honor.
Thank you.
Would the court allow me to address Ms. Gregg's bond?
Sure, let's spend all day on this. Go ahead.
Sorry, Judge. Your Honor, her bond is currently $5,000 with a 10% provision. She's unable to post that bond. That bond was set in mind with this charge being a felony. She has now pled to a 1-year misdemeanor. She spent the last 50 days incarcerated. Should she be released, she does have stable housing. That would be in Ypsilanti with a friend. She does also have employment lined up as well, should she be released. We would ask if the court would consider a personal bond. She's also been in touch with Community Mental Health, and she will be working with them upon release.
Response.
Just been in touch with mental health. We would have an objection to a lowering of the bond since it's been reduced to 6.
Okay, I will for bond to a $5,000 personal recognizance bond. Defendant, and with the condition to maintain contact and communication with Community Mental Health. Okay.
Thank you very much, Judge.
You're good.
Oh, yeah,
All right. Follow through on everything.
I will.
You hear me?
Yes, I will.
All right. Thank you.
Thank you, Judge.
All right, good morning again, everybody. Welcome to the Courtroom Files Live. Happy Thursday to all of you. I've got my eyes on 12 different courtrooms at the moment, and there's a lot of action out there this morning. It's a busy day. Hopefully that means it doesn't all fizzle off early, because sometimes that happens. They get off to this rousing start, and then the next thing you know, everybody's cleared out their courtrooms. But we'll see how it goes. Let's head southeast, just a short jaunt to Woodhaven, and we'll say good morning to Judge Dad.
You have the right to a lawyer. Do you want a lawyer? Yes. Okay, I'll set you up with a lawyer. You can go out in the hallway, talk to them, and then either way, you're coming back in front of me, okay? You're welcome. Al-Shami. Amin Hamoud Ahmed Al-Shami, 25R 514-112. Could I also have seated up here Eric Kosh, seated at the table. Eric Kosh, Kosze. Your name, sir?
Good morning. My name is Amin Al-Shami.
You're charged with furnishing tobacco to a minor. You have the right to a lawyer. Do you want one?
No.
It is alleged that this occurred at 22430 Huron River Drive in Rockwood, April 19 to 25 at 8:08 p.m. That is a misdemeanor punishable by up to 500 fines, 90 days jail, costs, or all those. Do you understand that?
Yes, sir.
Did you sign, read, and understand the advice of rights form?
Yes, sir.
If you plead guilty, at any time, you'll be giving up all those rights and there will not be a trial. Do you understand that?
Yes, sir.
All right, you have the right. You still wish to waive your right to a lawyer?
Guilty.
You still wish to waive your right to a lawyer? Let's slow down. Do you still wish to waive your right to a lawyer? Yes? Okay. I'm gonna enter a not guilty plea. Pardon?
Yeah, I'm not guilty. I'm a guilty. I'm sorry. I'm guilty.
Just slow down.
Yeah.
I'm a judge, not a priest. Relax. I'm gonna send you to the prosecutor. I'm gonna let you talk to the prosecutor. Maybe he'll offer you something, okay? All right?
All right.
So I'm entering a not guilty plea, personal bond. You go out in the hallway and they will set you up with the prosecutor, okay?
Thank you.
You're welcome. Thanks. David Kasser. David Kasser. This is David Kasser versus Richard Kowalski. 2501702. Mr. Kasser, your appearance? Yep, you have to unmute. Yeah, I know. One's going to an attorney, one's going to prosecutor. Mr. Kasser, your appearance? I can't hear you.
I am David Kassar, Your Honor.
Mr. Kowalski, your name?
Richard Kowalski.
Mr. Kowalski, did you listen to and understand the rights on the video?
I did, sir.
Wish to speak to a lawyer?
No, sir.
You intend to apply for funding.
I did, sir.
When did you apply for funding?
About a week and a half ago.
All right.
Through the Michigan 411.
Here's what I'm doing. I'm adjourning this 2 weeks. Defendant to provide proof. This is what you have to do now. You have to provide proof that you've applied for funding with the court. So you have to come up here and bring it up to the court within 5 days. Within 5 days. Do you understand that?
I do, Your Honor, but it was all by over the phone, and she said there was no funding available for me because I'm 52.
Okay, well, then you're not applying for funding.
But no, there's no.
Wait a minute. I didn't hear you, sir.
No, the woman I spoke to on the phone said there was no option for funding for me.
Okay. So you're not applying for funding then?
No. I tried. I looked into it, but there was no funding available.
All right, Mr. Gasser, why don't you tell me how much is owed on this?
Your Honor, this is a termination case.
Oh, geez, I'm sorry.
That's okay. That's my fault. I should have mentioned it. But it's a termination case, and there's no lease involved.
Why don't you have to move out, Mr. Kowalski?
Excuse me, sir?
I said, why don't you have to move out?
I do have to move out, but I don't have the funding right now, and I'll be homeless. So I'm just trying to find time until I get my back.
I got to be able to pick you up. I don't know what's going on here. You're going to have to start over. You've frozen on the screen here. So, can you hear me, Mr. Kowalski? Oh, man. Jennifer, any ideas?
Looks like he just disconnected, so he must be having internet issues.
All right, well, chat with him and tell him he needs to come up here.
Oh, wait, he's back. Let's see if
Okay.
Mr. Kowalski, can you hear us?
Mr. Kowalski, can you hear us?
Maybe I could call him on the phone. On another phone.
Why don't you do that? And you can tell him that the judge would like him to come up to court. Because it's pretty clear we're not going to be able to do this by Zoom with him. So you go ahead and do that, mute yourself. I'll go on to another case and we'll go from there, please, okay?
Your Honor, I can hear you now.
All right, Mr. Kowalski.
Your Honor, I can hear you now.
All right, good enough. Mr. Kowalski, why don't you have to move out of the property?
I do have to move out. I'm paid rent. It's not intentional. I was off work due to an injury. And then when I got back to work, it was too late.
Okay, what do you want to do here, Mr. Casser? You want a 10-day writ, or what do you want to do?
Maybe we can give him 2 weeks, Your Honor.
Till the what day? The 29th?
The 29th is fine. That would be great.
All right, Mr. Kowalski, I'm going to go ahead and indicate, and I'm going to fill out this judgment. The plaintiff has a right to possession of the property. I'm going to extend the writ date until May the 29th. If you're not out by then, he's going to submit an application for a writ, and I'm going to sign it. Okay? No money judgment is entered. Acceptance of partial payment will not prevent the court from issuing an order. Not that there is any payment to be made. Defendant may be liable for money damage after moving if additional rent is due, or if there's damage to the property. So you have to be out, sir, by May the 29th. If you're not, then he's going to make an application. For a writ. I'm going to sign it, and you're going to be evicted, okay?
I will be out by the 29th, sir.
Good luck to you. I wish you well. Thank you. I filled out the judgment, Lisa, in here, or Jennifer, rather. You can send it out. Thanks.
Thank you.
Gosh.
Thank you.
I predict Dad's gonna lose it here shortly. He seems a little edgy, but I prefer happier mood at the moment. So let's go back to Judge Simpson.
Thank you.
Thank you.
Thank you.
Court calls the case of the people versus Areli Benzara. Vilches.
Ashley Lonnie for the people.
Good morning, Judge Lawrence H. Margolis, and on behalf of Ms. Barraza Vilches, Ashley Areli, please state your name.
Good morning, Judge. Areli Barraza Vilches.
Okay, what are we doing?
Judge, it's the first, I believe we're waiting on some discovery. I'm asked to adjourn it, and I would defer to the prosecutor as to the time she would like.
Your Honor, there is outstanding discovery, specifically the autopsy, as well as the lab results. So that's going to take a little bit of time. I can't say with any definitive
Understood.
facts how long, but it's going to take at least a few weeks, I would think.
Probable cause conference will be adjourned June 12th,
Will people be heard on bond?
2025, 9 a.m. Yes, that's the bond.
Your Honor, could the court inform us how many times the defendant is testing per day? She's on a sober link. I couldn't quite tell if she got a sober link or a scram.
So she had.
I have her on a location tracking. I think I have her on a scram.
Excellent. Thank you, Your Honor. Nothing further.
Bond will continue with its conditions. Thank you.
Thank you, Judge.
Court calls case people versus Danielle Landman.
Your Honor.
Carolyn Foster Tucker on behalf of Danielle Landman. You state Danielle Landman.
Thank you. Yes.
Alrighty, let's do this. Let's say good morning to Judge Meineke. We'll go there.
That are suspending your license. Just two. One out of Detroit, a no-proof insurance from July of 23, and one out of Roseville from last October. If you pay both of those tickets, then you can go in and renew your license.
Okay.
So that's part of what our program does, is we provide people with information. Let's see here. Hold on. Okay, so what you want to do, Mr. Clark, is call. I'd call Roseville. You can go online to Detroit. If you go online to Detroit, you're looking for a no-proof insurance that took place in July. They have a pretty good case lookup. And when you see the specific ticket that deals with no-proof insurance, you probably have other tickets there. And you will have to pay them all eventually. But you can be a little surgical and specific with the way and the order and of which you pay your tickets. Pay these no-proof insurance first, because that will open the door for you to go make your appointment with the Secretary of State and renew your license. Now, it's been more than 4 years since you had a license, so they're going to make you do a written and road test. Just be ready for that, okay?
Yes, sir.
All right, so I'm not imposing any fines and costs right now. If I did, it would be into the it'd be over $1,000. I don't have an interest in taking that amount of money from you, so I'm going to delay all payments. If you have money, Mr. Clark, pay those other courts, pay Detroit, pay Roseville, pay the ones that are suspending your license. And so on our end, I will wait, and once you get your license, I will substantially reduce your fines and costs and give you a payment plan, okay?
Yes, sir.
All right, so we're gonna send you notice, and it's okay. It's okay just to log. It's okay just to dial in. You don't have to worry about having Zoom. You can call in like you did today, and I'll see you back here in about 90 days. Okay?
Yes, sir. And I promise you, I have my license back.
And don't worry. You don't have to wait to see me. There won't be anything from this court holding you up. So once you take care of Roseville, once you take care of Detroit, go see the Secretary of State. Good luck, sir.
Thank you. I appreciate it.
All right, take care.
Thanks, Your Honor. Good
You have
luck,
a blessed-
Clark.
All right. Have a blessed day.
You're all set.
All right, thank you.
Ms. Cole, do you need to speak to Mr. Barry?
Yeah, I just want to ask you, Mr. Barry, did you remove the film from your car on the windows? You're on mute, though. You have to unmute yourself.
Mute.
There he
There
is.
you go. Do you still have the film on your windows?
No, ma'am.
Did you take it to a place to remove them?
Yeah, I had the receipt. It's it's out in the vehicle right now, but I'm in the house, but I have it, yes.
So, Miss Chris, maybe you'd make a verbal motion on that file?
Yes.
Defective equipment. There we go. Judge, if we could just address Barry before Miss Chris gets really busy.
Yeah, sure. Yeah, she currently has she's made an offer.
Mr. Barry.
Yes.
Mr. Barry.
Yes.
So Miss Chris has made an offer that originally the offer was driveway license suspended and the tint would be dismissed upon an allowing in defective equipment.
Yes, Your Honor. And if I, and Chris, appearing on behalf of the city of Berkeley, Your Honor, at this time, people would move to dismiss the tint based upon Mr. Barry's representation that has been removed.
Okay, so we're on the record on 25-00-535. Miss Chris already put her appearance on the record. Miss Cole.
Susan Cole on behalf of Mr. Kamante Barry.
All right, Mr. Barry, can you state your name, please?
Yes, Chimani Barry.
All right. And so Miss Chris can keep moving on to whatever other rooms, although I actually don't think there's anything else ready for her right now. So this is the time to get Miss Chris. Are you also ready on Miss Johnson? Miss
Yes,
Cole?
Your Honor. It's just two very different type of pleas. So, because Mr. Barry has his license, and then Miss Johnson is a OWI and Operation Drive candidate.
So she won't go officially into Operation Drive. We will do Operation Drive like support in our regular probation. So she doesn't have to report multiple times to court. Okay. I could actually still take care of them both at the same time and get everybody moving. Miss Johnson, please state your name.
Vanessa Johnson.
All right. So Mr. Barry, Miss Johnson, please raise your right hands. All right. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God, Mr. Barry?
Yes.
And Miss Johnson?
Yes.
All right. Go and put your hands down. All right. Mr. Barry, you're pleading guilty to allowing an unlicensed person to drive. That's a misdemeanor charge, carrying with it a maximum possible fine of $500 plus costs and up to 93 days in jail, all at this court's discretion. The original count's going to be dismissed, and the allowing does not go on your record. And if you do have a valid license, and you do, it will not affect that in any way. Ms. Johnson, you're going to be pleading to operating while visibly impaired and allowing an unlicensed person to drive and impeding traffic. The original 3 counts are going to be dismissed. Operating while visibly impaired is a misdemeanor, carrying with it a maximum possible fine of $300 plus costs and up to 93 days in jail. The allowing, as I've already discussed, is maximum fine of $500 plus costs and up to 93 days, and the impeding just carries with it a fine. Ms. Johnson, you also face 90 days of restricted driving. You won't lose your license, but it will be, well, actually, you don't have a license right now, but your privilege will be restricted for 90 days. So if we do get that license back, you'll have to drive with certain restrictions as a result of the plea for 90 days. All right. I do need to ask a couple quick questions. Mr. Barry, can you read, write, and understand the English language?
Yes, sir.
You hear and understand me?
Yes, sir.
Ms. Johnson, can you read, write, and understand the English language?
Yes.
Can you hear and understand me?
Yes.
All right. Mr. Barry, have you had a chance to talk to Ms. Cole about this case, and are you satisfied with her advice?
I don't really. I just got right on. I haven't talked to nobody since last time.
I kind of did a rush with Mr. Barry. Because you had gotten your license, we talked about that I'd get you
Oh,
something that
okay.
would not hurt that license, and that's this allowing, like we had discussed before. I asked Mr. Barry to join on early and,
Yeah, so ultimately, Mr. Barry, Ms. Cole has given you some advice previously. She was able to secure that charge. Do you want to have some additional time, or are you satisfied with the conversation you had and the plea that she was able to obtain for you?
I guess, I don't know. I guess, sir, I ain't, as long as I ain't in no trouble, that's all I know. As long as I ain't in no trouble, man.
Okay, so Mr. Barry, I'll walk through this for you real quick. So you're originally charged with driving while license suspended and the tinted windows.
Yes.
So the tinted windows, Ms. Cole got a dismissal on that one.
Okay.
Driving while license suspended, she was able to get that reduced. So
Okay.
the driving while license suspended, if that hits your record, it would be 2 points, and that license you just got would be taken away from you for another 30 days.
Okay.
So the charge that she was able to get was allowing a licensed person to drive. So it's a non-traffic case. Now,
Okay.
it sounds a little odd. I get that, but technically, if someone didn't have a license when they were driving a car, they were allowing somebody to drive, that person being themselves.
Okay.
The key with that charge, from what what I've seen and what I think Ms. Cole was trying to get for you, was that this charge does not go on your record, does not affect this new license. And then she's very familiar with me and how I sentence. If someone's got their license back, I'm going to give them a substantial reduction.
Okay.
So I guess ultimately the reason I asked that question, I just want to make sure that somebody's comfortable with moving forward with the agreement that's been put in place by their attorney.
Okay. Yeah, I just didn't understand. I didn't know, that's all. But yeah.
Okay, so with all that additional information, are you satisfied with the work that Ms. Cole has done for you to get a reduced charge?
Oh, yes, sir.
Okay. All right, Ms. Johnson, are you satisfied with the work that Ms. Cole has done on this file to get you reduced charges?
Yes.
All right. All right, before you enter a plea, you should understand you have the right to represent yourself or be represented by an attorney. If you cannot afford an attorney, one would and has been appointed for you at public expense. You have the right to a trial, either by me or by a jury. At that trial, you'd have the right to confront, cross-examine, question all witnesses brought against you. You'd have the right to have the court subpoena witnesses on your behalf. You'd have the right to testify if you wanted to, remain silent if you wanted to, and no one could say anything about you remaining silent. As you appear before this court, you're presumed innocent of this charge, and your guilt has to be proven beyond a reasonable doubt. Mr. Barry, do you understand that once you enter a plea, you give up all those rights that I just said that you have at a trial?
Yes, sir.
All right, do you understand that, Ms. Johnson?
Yes.
And once you enter a plea, Mr. Barry, there'll be no trial. You understand that?
Yes, sir.
You understand that, Ms. Johnson?
Yes.
Other than each of you received a plea bargain, so a reduction in charge. Other than that, has anybody else promised you or threatened you in any way, Mr. Barry?
No, sir.
All right, Ms. Johnson, anybody else promise you or threaten you in any way?
No, Your Honor.
In the end, Mr. Barry, it's your own choice to do this. Is that true?
Oh, yes, sir.
And Ms. Johnson?
Yes.
All right. Ms. Chris, did you see that note from Mr. Perkins? He wanted to talk to you again.
Oh, I did not. I apologize. I'll go back and.
Yeah, I'll get rooms for you. All right, Mr. Barry, this is real simple. March 24th of this year, 2025, were you in the city of Berkeley?
Yes, sir.
And did you allow an unlicensed person to drive your vehicle, that person being you?
Yes, sir.
All right. Satisfied, Ms. Cole?
Yes, Your Honor.
I too am satisfied the plea is knowing, voluntary, and accurate. I will accept the same. I'm quite pleased to see that Mr. Barry took care of that ticket out of Detroit and got himself.
And right away, Your Honor, he didn't realize he was suspended and he was already reinstated by the time of arraignment.
Yes, that's quite an impressive turnaround. Anything else you'd like to say, Mr. Barry, before this court imposes sentence?
No, sir. I like really didn't even know I was suspended. That's why I didn't know. Cause the time I caught the ticket in Detroit, I had surgery the next week. I got shot 6 times a year or so back. And when the time I caught the ticket, I was in surgery and I completely forgot that I even had caught a ticket. I was healing up. I didn't even know I was suspended.
Well, Mr. Barry, I'm going to give you as big a reduction as I possibly can in fines and costs because you took care of it right away.
Sure.
So the maximum fine, it's a sentence of this court. on the charge of allowing a licensed person to drive. The maximum fine is $500. I'll set it at $25. The maximum court costs are $500. I'll set that at 0. I can't do anything about the state of Michigan costs. Those are $125.
Okay.
But the grand total all in is $150.
Okay.
And it will not affect your license. If I give you like 60 days to pay it, is that enough time?
Oh, that's more than enough time. It'll be completed in a couple of days, but yes, sir, that's more than enough
Great.
time.
Just to cover you, because I know you're, obviously coming off a significant recovery.
Yes.
I will give you the 2 months. Just make sure it's done before the 4th of July. All right.
Yes. Oh, it will be.
All right. Good luck, Mr. Berry. Take care of yourself.
Yeah. Thank you.
All right, Ms. Johnson, directing your attention to March 10th of this year, 2025. Were you driving a motor vehicle on Woodward and 12 Mile in the city of Berkeley?
Yes.
All right. And at some point in time, were you stopped by the police?
Yes.
All right. And when you were driving that vehicle, were you allowing an unlicensed person to drive, that person being you?
Yes.
All right. And you do plead responsible to impeding traffic, which is the reduction from the speeding. Is that true?
Yes, Your Honor.
Okay. All right. And now at some point in time, after you had contact with the police, did they have you step out of your vehicle, do field sobriety tests?
Yes.
And then were you placed under arrest?
Yes.
Okay. And then did they take you back to the Berkeley Police Department?
Yes, Your Honor.
All right. And at some point in time, did you do a breath test there?
Yes.
Okay. And counsel, for purposes of this plea, stipulate to a .120. Is that right?
So stipulated, Your Honor.
Ms. Johnson, what did you drink to get to that bodily alcohol content? Was it beer, wine, liquor? What was it?
It was wine.
All right. Looking back on it now, with the benefit of hindsight, would you agree that your ability to operate that vehicle in a normal manner was substantially affected by your consumption of alcohol?
Yes.
All right. Satisfied, Ms. Cole?
Satisfied, Your Honor.
I too am satisfied the plea is knowing, voluntary, and accurate. I will accept the same. Counts 1, 2, and 3, the primary counts are dismissed, and in their place are going to be the operating while visibly impaired, the allowing unlicensed person to drive, and the impeding traffic. Now, I'm going to order a pre-sentence investigation and alcohol screening assessment. I have to do that by law. So here's what's going to happen, Ms. Johnson, to get you sort of prepared for where we go from here. You're going to get 2 more court dates. All right. And those 2 court dates, the first one will be an interview with probation. And don't worry, Ms. Johnson, we're going to send you all this information. Okay. So you don't have to worry about writing it down right now. And you'll be interviewed by probation on Zoom, like you and I are talking right now. They'll get information about you. And then from that, they'll prepare a report. And that report will contain recommendations of what they think I should sentence you to. Now, you and Ms. Cole will get a chance to take a look at that before you come in and see me. So you'll be able to make any arguments or corrections or anything like that. And then you'll come see me in person for sentencing. Now, in the meantime,
right, Your Honor, we do have to address testing.
Yeah, it's very important. It's very important that, right now, I don't know anything about you, and we do want to make sure that we're doing testing. It's my understanding that there are some financial challenges, and the bond said a sober link. I don't know that I need to have her on a sober link, Ms. Cole.
Right. She could not afford the sober link, Your Honor. And when she addressed that with pretrial services, which she has kept in touch with, they said they needed a new court order. They couldn't just switch her. So now during my arraignments, I always ask for either or for my clients once they realize the costs. So she is on probation in Macomb County, Your Honor, and she has been testing with her probation officer, although that's just once a month. So I would just ask to let pretrial services have her do random testing.
If I leave that up to pretrial services and I say random testing, they'll just throw a couple. They'll just throw a couple PBTs here and there, and that's
okay.
What she's doing now is more than I need her to do. Okay, so especially expense wise, but obviously the level of testing that they did in her probation in Macomb was not sufficient because it didn't stop this enterprise. But
excuse me, Your Honor. I'm sorry. So when this incident occurred, March 10th, I was not yet sentenced to my probation. So I wasn't on probation when this incident occurred. I wasn't sentenced until April 17th. That's why I was not being tested. And this incident, this was like, I could count on one hand how many times I've indulged in any substance. This is maybe the second time, Your Honor. So this is not like a reoccurring thing.
Oh, I understand that, Ms. Johnson, but I would imagine that on your original bond condition for your Macomb County case, even if they weren't testing you, they probably had a condition that said no alcohol or controlled substances. And then this.
My Macomb County case, I didn't have any bond conditions. It was like I didn't have any bond conditions set to whereas like I did for Oakland County, like how I was supposed to drop before I got sentenced and all of that stuff. I didn't have those bond conditions. It was just wait for your court dates.
Oh, well, Ms. Johnson, things are very different than here, and I do want to tell you that with you being on probation, and with this case as well, I mean that's two pretty quick cases in short order. So, and you're not actually testing right now, and so basically this court could just come to the conclusion that, you know what, we need to go with some type of upfront jail. I'm always looking for reasons not to put people in jail. And so I recognize that with your financial situation, a sober link doesn't really make sense. It's just too much money, and it's something that I think would be very difficult for you to comply with. And so I'm going to amend her bond so that she doesn't have to pay all of that money like she would have to on the sober link, to simply 5 times a month on the ETG. So 5 times a month, she's going to have to alcohol screen on the ETG. Now, Ms. Johnson, if you test positive, then we could be looking at a jail sentence. But if you make a best effort and you stay clean, you stay clear of that stuff, then I absolutely will consider a probation. Now, what is absolutely crucial is that you probably in Macomb got a probation order, a list of terms and conditions, so that you know what you're supposed to do for them, right? Okay.
Yes.
When you talk to my probation department, make sure they get that, because although these are different types of cases, all right, and we do different things, where I can try to coordinate so you don't have to double up, pay extra money, take extra classes, do double what you're doing. We'll try to work with that probation department, but we need to know what you're doing in that other case. Okay.
Okay.
All right, so I've amended her bond, so she doesn't have to worry about being in trouble with pretrial services or getting a sober link. And then we'll just set that up for Ms. Johnson. And we'll see you back here for sentencing. It should be about 4 to 5 weeks, but my probation department will be in touch.
Okay.
Thank
All
you,
right.
Your Honor.
Good luck, Ms. Johnson. Thank you, Ms. Cole.
Yep. Thank you, Your Honor. Follow up with me, Ms. Johnson, okay? Any questions? Thank you.
Alrighty, busy courts today, but I'm looking across YouTube and Rumble and X and all the different places that I monitor courts, and there's not a lot of viewers out this morning, so maybe everybody's just in court. I hope not, but maybe that's it. Let's go back to Judge Simpson and see what's going on with him.
From Northfield Township, Washington County, State of Michigan. Did you have heroin in your possession?
Yes, Your Honor.
Did you use it?
Yes, Your Honor.
And did you know what you were using was heroin?
Yes, Your Honor.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Defense is satisfied, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. A pre-sentence investigation and report is ordered at 1483 probation. Sentencing in this matter will be
June 16th at 9 a.m. for Judge Freshour.
June 16, 2025, 9 a.m. before Judge Freshour. Bond with its conditions will continue. Thank you.
Thank you very much, Your Honor.
Court calls case People versus Larzell, Washington.
Good morning, Edward Dukes on behalf of Larzell, Washington.
How you doing, Your Honor?
I'm doing great. What's your name?
Larzell O'Neill, Washington.
Thank you.
Thank you, sir. Your Honor, we had referred this over to the recovery court. I spoke with them and they indicated that they've in receipt of all the information to do an intake. However, they have not done that interview could be completed within the week. Like if we could have a 1 week adjournment.
Probable cause conference, May 22nd, 2025, 9 a.m. bond continued. Court calls case People versus Marquis Fab.
Oh, excuse me, sir.
Yeah.
Can I please have a word? With all due respect.
I think Mr. Washington would like to address bond.
Excuse me,
Go ahead.
How you doing, Your Honor? My
I'm
name is
great.
Roselle near Washington. First and foremost, forgive me about my outbreak last time I was here.
Can I have that file?
Thank
Go
you,
ahead.
sir. Thank you, sir. What happened was I wasn't aware, as my attorney indicated, what day was my probable cause hearing was. Okay, I went back to the magistrate. They said, no, well, we're gonna let Judge Simpson handle it. Then last time I came here, it was a 2-week hold because they didn't do their job. I feel I shouldn't have to be.
Who didn't do their job?
What you say? You gave him a plea.
The recovery court?
Well, I didn't ask for no recovery court, but whatever assessment you gave him, it was 2 weeks. And the honorable judge said, okay, well, I'm not going to change his bond. Now, you still didn't indicate I was looking for a bond. And I wasn't even aware of a drug court. So with all due respect, I do appreciate you, but I did, unfortunately, miss my court date.
Right.
I was.
And then how'd you come into custody?
Oh, I came into custody? What? Trying to be a good Samaritan. Some woman was being stalked, and they figured out what my name was, and I totally forgot. I really didn't know what court date it was. And I was disciplined for the first, and in the discipline, well, not necessarily discipline. You allowed it to, override until they took care of their own situation, but it's not my fault.
So who is they?
Would you explain to him?
Well, I think I got to collect more of that story.
Okay, you gave him a piece of paper about assessment along with a plea.
Mm-hmm.
Okay, I get here today, the assessment got taken care of. Right?
You just want them to speed up the process. I think
not them. It's not his fault. He's a judge.
Mm-hmm. Thank you. That's right. Nothing is my fault.
No, it's not.
That's right. I know.
Amen. So I'm saying, I'm just trying to, sir, live my life. I normally work the carnival shows. I have really been disciplined for not being aware of to show up. I'm not dumb enough not to show up again.
Excuse me one moment. Whose phone is that? It's somebody down there's phone. Is hers? Tana's phone? Really? Go ahead, sir.
And I'm not ignorant enough not to show up in front of Judge Simpson courtroom again.
I think he is saying that he would show up to court next time. He's asking for a PR bond.
Yes, I am, sir.
If the court would not provide a PR bond at this time, if the court would allow an interview to take place, if that interview takes place, then the court provide a PR bond.
I never said that. I asked, could you please provide a PR bond? And I will.
I addressed this the last time you were here.
What was it about?
I think they're going to keep you in.
All right, man. You're fired. God bless you. And thank you, Your Honor.
Why is he fired?
Because he's not speaking up for me. I really don't even know what's going on.
Oh, it would. Okay, so did you understand before you make that final decision about firing him? Well, it wouldn't have mattered whether you spoke or he spoke. I was denying your motion. I've already heard it.
Well, I don't know. Why are you denying the motion? And what's so funny?
Because you appeared here, didn't show up, didn't turn yourself in, got picked up, got brought here.
Yes.
That's how we got you back.
And the
So I'm
magistrate,
not releasing you
right, the
now.
magistrate
Okay, so
did not release me, and then
that's right.
you didn't release me
That's
because
right.
you wait for assessment. Am I correct?
And I haven't had the assessment yet. Have I?
Exactly. So is it my fault you haven't had assessment? Is it your fault?
It's my fault? I thought nothing was my fault.
So whose fault is it?
I don't know.
But it's not mine. You do agree?
No, I don't agree.
The assessment, do I?
I don't know whose fault it is. It hasn't happened. I'm done.
Pretty much. God bless you.
Thank
you, Your
you.
Thank you, Your Honor.
Well, keep talking. Why are you up here at my, why are you at my podium? Why are you at my podium? Next time, Tana, turn your phone up louder when that's going on.
And then it was.
Did I call your case?
Yes, you did. You called, Mr. Babb, Marquise Babb.
Oh, that was so long ago. You're right. You are right, Miss Cannon. And I usually criticize you for not getting up here on time. And I have to give you credit that you're like early.
Got it, Judge.
Court calls the case, people of the state of Michigan versus Babb.
That is done on behalf of the people, Your Honor. Stephanie Cannon, on behalf of Mr. Babb, who should be appearing by Zoom. Oh, thank God.
Mr. Babb?
Please be there. So what had happened?
Marquise Babb, you need to unmute and turn on your camera. Every week, Cannon. Every week.
I was doing my part today. Your Honor, we're just setting it for a preliminary exam.
What?
We're simply setting it for the preliminary exam.
I gotta have him, I don't know who, I gotta have him here. Oh, you're just gonna call him?
Yep.
So while we're waiting on that, there's a lot going on in a lot of courtrooms, but quite honestly, Judge Simpson's in a good mood and his court is the most entertaining. So I'm content to ride here for a while if you are. Put a 1 in the chat if you want to stick with this. Put a 2 in the chat if you prefer me to move around. Just let me know what your thoughts are.
Practicing law by janaza. That's what you're doing right now. This is
Great, he got it.
yes, acting really, this is so you. You're like, what? Oh, uh-oh. Mr. Babb?
Yes, sir, Judge.
All right, you got your camera on?
You need the camera as well?
Yes, Mr. Babb.
That is his camera on.
Yes, it's already.
Is that Mr. Babb?
That's Mr. Babb, Your Honor, yes. The good news is he'll be here in person the next time, Your Honor.
I won't be here to witness it. It's going to somebody else. All right. All discovery is complete, Ms. King.
Yes, Your Honor. Discovery is
People
complete.
have their witnesses available the 27th. Preliminary examination in person, May 27th, 2025, 9 a.m. That's before Judge Fresh Hour.
Thank you so much, Your Honor.
Thank you. Bond will continue. Court calls case of the people versus Marvin Sullivan.
Andrew Childress appearing on behalf of
James Fifelsky appearing on behalf of Mr. Sullivan, who is approaching. State your name for the judge, please.
Marvin Sullivan. Thank you.
Your Honor, this is the first PCC. I'm asking for an adjournment for discovery and investigation. so I can review discovery with my client. And if I could possibly address bond, I would appreciate it.
Probable cause conference, May 29th, 2025, 9 a.m. I need a screen sheet.
Your Honor, I know you hate it when I do this, but I actually have a trial in Wayne County that day. Could we do the 3 weeks out?
June 5th.
Thank you very much, Your Honor.
2025, 9 a.m. Esteban.
Your Honor, it's my understanding a $10,000 bond has been set in this case. My client has a lot of family in and around Romulus. He would reside with his mother in Romulus if he were bonded out. Has been gainfully employed doing demolition work out in Detroit, has 3 kids, custody of, I think, 2 that are in Michigan. And to my knowledge, I haven't had a chance to verify this, but it does not have any prior convictions involving firearms or assaultive activity. And I believe that while he has another pending case, that case has a PR bond. So I would ask the court to consider a low cash bond.
What's his other pending case?
No.
I'm not sure.
They got dropped to driving without ops on the person.
Maybe a misdemeanor case.
So he's got another weapon charge.
Apparently so. I don't know anything about it, but it has a PR bond, so.
But that case preceded this one. And then he picks up this one.
I don't know.
Actually, the other case that he has your honor is the other issue is that the defendant does have an extradition warrant from Mississippi. And we haven't, and I did verify, I spoke with Ms. Burton Harris yesterday about this in our office. We're awaiting the actual governor's warrant in Mississippi, but we have verified that there is a warrant. There is a warrant for him out of Mississippi,
but we don't have the governor's warrant yet.
Correct. And so there is a CCW. Mr. Sullivan has a pending CCW charge now, 8/27/2022. And then the facts of this case I believe in the fall. So that the older CCW, which is still pending, predated this offense. Mr. Sullivan does have a prior CCW conviction under HIDA, I believe in 2012. And obviously this case involved possession of firearms, shooting it in the vicinity of a Washington County Sheriff's deputy who was training a canine in the back of the parking lot. It's not charged with, he wasn't charged with shooting at that deputy, but the reason this came to law enforcement's attention was the deputy was training his dog, heard gunshots and saw a car drive off. And our allegation is that it was Mr. Sullivan who was shooting, basically testing out his new gun that he shouldn't possess in the vicinity of the deputy. I'd ask the bond, frankly, the $10,000 bond seems low.
Anything else?
Nothing further, Your Honor.
Didn't think so. Bond denied, motion for bond reduction is denied. Bond will continue. Thank you.
I'm down. Thank you, Your Honor.
Court does call the case of the people versus Cassandra Bure. Four. Sorry to wake you.
Sorry, I'm so busy. I'm busy probably handling her case. So, Your Honor, Assistant Public Defender Jay Bellinger on behalf of Ms. Bohr. Ms. Bohr, can you please state your name for the record?
Cassandra Bohr.
Court has before the plea form. Is that what we're doing?
Yes, Your Honor. I have an advisory right before me.
All right. plea form indicates that the defendant would be pleading to an added count 3 of operating while intoxicated second offense, the 1-year offense. Upon a successful plea of that charge, counts 1 and 2 would be dismissed. That's the court's full understanding of the agreement.
That's our understanding as well, Your Honor.
That the people's understanding?
Yes, Your Honor.
May I have the defendant sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Cassandra Ball.
All right, ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated second offense. Is that correct?
Yes, Your Honor.
All right, that is a misdemeanor, punishable by up to 1 year incarceration, a $500 to $1,000 fine plus court costs. Do you understand that?
Yes, Your Honor.
You understand that the court could also order community service, any rehabilitative services the court deems necessary, could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes, Your Honor.
All right. You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Washington in the 14B District Court. You
Yes, Your
understand?
Honor.
All right. Now, understanding all of that, you still wish to plead guilty.
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding those rights?
No, Your Honor.
Please look at paragraph 5. Those are your rights which are a part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Anybody promise you anything other than what's been stated here today to get you the plea?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
and because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
May 27, 2022, at the location of US 12 and East Horse Road in Ypsilanti Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes, Your Honor.
What'd you have and how much?
I had drank beer during the day, ate, and then I went to a bar and I had liquor, a couple drinks at the bar. I hadn't drove it all that day other than returning home that night when I got pulled over.
And Your Honor,
Were you stopped by the police or was there an accident?
I actually hit a ditch with my boyfriend's car and yeah,
So
the
there
police
was
were
an
called to the
accident.
scene. I couldn't get out.
You
of
didn't
the
do
ditch.
that on purpose, did you?
No, Your Honor.
So there was an accident? Not with
Yes, Your Honor.
beer? All right. Did the police arrive?
Yes.
All right. Were you ultimately arrested?
No, Your Honor. I was taken to the hospital for a blood withdrawal. And then I checked myself.
But
into
you
the
were
hospital.
taken there in a police car
Well, yes, Your Honor.
right?
Yes,
So you were arrested.
yes,
You weren't free to leave at that point, correct?
correct.
All right. There was a blood draw.
Yes.
All right. What were the results of that blood draw?
Your Honor, we would stipulate to 0.277.
277? Ma'am, do you have any reason to dispute those blood test results?
No, Your Honor.
Had you previously been convicted of operating while impaired on or about April 18th, 2013 in the 18th District Court and or operating while impaired on or about June 30th, 2014 in the 34th District Court out of Romulus?
Yes, Your Honor.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report and screening and assessment is ordered at 14B District Court. Sentencing in this matter will be
July 3rd at 10 a.m. with Judge Washington.
July 3rd, 2025, 10 a.m. before Judge Washington. Bond with its conditions will continue. Thank you.
You're all set, okay?
Court calls the case of the people versus Kenia Jackson.
Ashley Lonnie for the people.
Mac appearing on behalf of Ms. Jackson. I don't know if Ms. Jackson joining us.
Who do you have?
Burmeister. He's pulling on Jackson right now.
Okay.
He's pulling Jackson right now.
Okay, thank you.
While they get that person, indulge me for a minute, if you will, please. 54 years ago today, my mother and my father got married. Now, Dad left us in 2018, but Mom has never considered herself to be a widow. She is still married, and today she celebrates 54 years with her husband. So if you'd be so kind in the chat, please wish a happy anniversary to my mother and my father, quite frankly. 54 years today. Let's get back to Judge.
Approach.
All right, he's muted longer than I thought he might be. Let's go to Judge Washington
Drug
for a
and
few
alcohol
minutes.
tests, but none are being required at this time. There's no use or for possession of alcohol, marijuana, illegal drugs, firearm components, ammunition, or other dangerous weapons. I'm going to do a review in 3 months, so that's 90 days. And at that point, we'll see if you've done all the things you're supposed to do, which really boils down to pay your fines and costs, complete the program, and make sure you don't basically violate these orders by assaulting anybody else. So if you've done those things, then at that time you would be eligible for early discharge. Do you understand that part, ma'am?
Yes.
All right. So do what you got to do, get it done, and then you can be discharged from probation. I will see you back here on August 14th, 2025.
Okay, thank you.
You're welcome.
Thank you, Your Honor.
You're welcome.
All right, Judge Simpson's back now.
All right. But that's today's about.
Thank you, Your Honor. We would mutually request, myself and the prosecutor, that we.
I need a green sheet prepared. I'll adjourn probable cause to May 22nd,
Yes.
2025, 9 a.m. Bond continued.
I can put that we requested. It doesn't matter.
Court calls the case, People versus Michael Brooks.
I'm seeing this.
Okay.
Public Defender Jay Bellinger on behalf of Mr. Brooks. Oh, I think he's on, yeah.
Michael Brooks.
There he is.
Need to unmute and state your name, please.
Can you hear me now?
I can hear you now. State your name.
My name is Mr. Michael Brooks.
Thank you.
And Your Honor, we are just requesting a step for examination at this time. All discovery is complete to the best of my knowledge.
People have their witnesses available the 27th.
I'm sorry, Ron.
Preliminary examination in person, May 27th, 2025, 9 a.m. That's before Judge That's before Judge Washington.
Thank you, Your Honor.
Bond will continue. Court calls the case People versus Kyle Burmeister.
Alexander, on behalf of the people, Your Honor.
Assistant Public Defender Jay Ballinger on behalf of Mr. Burmeister in case ending in 5078, Your Honor.
James Vithelski appearing on behalf of Mr. Burmeister on the case ending in 5028.
Burmeister, can you please state your name for the record? And Your Honor, we're just requesting a 3-week adjournment for purposes of him going in inpatient. He's just awaiting a bed right now.
That is correct, Your Honor.
Probable cause conference, June 5th, excuse me. 2025, 9 a.m. Bond will continue.
So I'm just.
The way you heard that.
It doesn't sound. All right.
Sit up here, not doing anything. Yeah, once again. Thank you, Your Honor.
Court does call the case of the People versus Winona Harvey.
Harvey.
Morning, Your Honor. Hannah Mack, requesting permission to practice under Michigan Court Rule 8.120 under Public Defender Brian Bowling.
Permission to practice is granted. Good morning.
Thank you, Your Honor.
All right. Ms. Harvey, can you state your name?
No, I can't. I know, you got, my last name, Michelle. Where are you? Where are you?
I met with you in jail yesterday.
Look, if it's gonna skip, okay, yeah, okay.
All right. You're Miss Harvey?
Yep.
Okay. You're seeking an adjournment?
I am, Your Honor.
No, not you. I'm not Miss Harvey. People don't miss Harvey. I'm Harvey. I'm Harvey like that. People don't miss me, but I'm Harvey.
Okay, so maybe she doesn't want to be addressed as a Mrs.
Understood.
No, I know miss. People don't misses me or nothing. I'm the Harvey.
Sorry about
My apologies.
Okay.
Probable cause conference will be adjourned June 5th, 2025. 9 a.m. Bond continue.
We'll be in touch, Harvey, okay?
When?
I'll come visit
Excuse me,
you.
what's going on?
We just adjourned your case. Winona, remember we spoke yesterday and you said
Until when?
Which date did you get?
June 5th.
June
Sorry.
5th, you want to see me?
No, I'm going to see you before then.
Look, I'm not going back. I can't go back to the conference room. That hurt my back a lot. That room you took me and hurt my back a lot.
Okay. I'm going to let you talk to your attorney some other place, okay?
Okay,
Thank you. Shut her, please. Clerk calls the case, People versus John Fulton.
We're ready. Deputy Chief Public Defender being on behalf of Mr. Fulton, he's in the lockup, should be on his way out. Today is the date and time set for the probable cause conference. I believe that we've adjourned this matter because we're waiting for a mitigation report. That mitigation report is almost complete, so we'd ask for one more adjournment. We've got the final piece of information we need.
Probable cause conference, May 29th, 2025, 9 a.m. Bond continue.
Thank you very much, John.
Thank you. Gotcha. Court calls case People versus Demond Branford.
Brian Bowling on behalf of Mr. Bransford.
Your name, sir?
Lamar Bransford.
Thank you.
I have a green sheet, Judge.
All right. Requesting an adjournment.
I am, Judge.
Will be adjourned to May 29th, 2025, 9 a.m. Bond continued.
Your Honor, may I address one issue of bond? Would the court allow an order for him to be released to treatment if it becomes available?
If I get that order, I will sign off.
I will submit it. Thank you, Judge.
All right, we've spent the entire morning in Michigan, so let's switch it up a little bit and go say good morning to Judge Boyd.
Good morning, Judge.
Good morning. So, counsel, do you have all discovery now?
I do. We've gone through it. The state had recently given me some new discovery. I've gone through it with my client. He also provided videos, which I've gone through that I don't think my client needs to see, but they are potential Brady that we can use later if we need. So I think we need a trial date, Judge.
Yes, we do. Does he want a jury trial or a bench trial?
Jury trial.
With the jury.
All right. All right. How long do y'all expect this trial to last?
I would say at least a week.
I would think so.
There's a few videos. in it.
Oh, okay.
I mean, it has security surveillance that might be a little bit longer than the normal.
All right. If you all will speak with Ms. Ferguson on a jury trial date and then come back to me with the date that you all agreed upon.
Thanks.
Do you have any questions, sir?
And we did.
No, thank you.
We've sort of narrowed it down, Judge.
Judge, I mean, just looking at our schedule, the only dates that I see that if it's one of this year
Everyone, please whisper.
would be December, the Monday's the 8th, but December 9th is a Tuesday. That's, I mean, because everything else we sort of has.
It's booked.
Yes, Your Honor, unless you want to get it to January, then that's entirely up to you.
All right, this is what we'll do then. Mr. Marino, in this court, we're in trial every week. I don't like for people to have to wait for their jury trial. But the state can only try one case at a time. And I try to make sure that trials are placed on the docket as quickly as possible. The earliest date that we can give you is December 9th. Now, if for some reason there is an opening that opens up sooner, we can let your attorney know and we can have you brought over sooner. Do you have any objections to the December 9th date?
Well, for me, the sooner the better.
All right, let's go on the record. Court is calling 2023 CR 4371B State versus Marco Antonio Marino Vasquez. Can I have parties announced for the record for the state?
Jason Garahan, Your Honor.
David A. Garcia, attorney for Marco Moreno Vasquez.
And are you Mr. Marino Vasquez?
Yes.
All right, if I can have the interpreter, if you can raise your right hand. Do you solemnly swear or affirm do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand. So, as I was stating off the record, Mr. Vasquez, we try to get cases set in jury trial as quickly as possible. If I had 20 prosecutors in this courtroom, we could still only do one jury trial a week because I have other cases that I have to attend to as well. I know your case has been on the docket since July of 2024. There have been several issues that are outside. Oh, excuse me, just one second. Are you the first attorney on this case?
I am, Judge, but there have been a lot of discoveries that have come in over time And I think that's one of the reasons why things have been delayed.
And just for the discovery purposes, the CPS information just became relevant, or actually given notice to us, and actually just developed in probably the last few couple months or so. And then he does have a co-defendant that was set before him that ended up fleeing, and he's pending sentencing, so that may have complicated issues.
Okay,
So that might be something.
all right, because I'm looking at the time that he's been on the docket. He's actually been on the docket for what I consider to be a long time, but now that has cleared that up.
Right. And then I think one other thing was it came in as tampering as opposed to the murder.
And and it's still listed.
Right, it's still listed as tampering, and that was one of the issues that I had to contend with my client, because he kept arguing that he's only charged with tampering. And I was like, no, there's also a murder.
Well, and actually, I believe, my understanding is that it's a 3-count indictment. It's murder and tampering, and also, I believe, deadly conduct or something like that.
Yes, and then there's a burglary of a habitation. Well, no, there's a discharging of a firearm at a habitation. So, sir, you actually have 3 counts in your indictment. You have a murder count, you have a discharging of a firearm into a habitation, and then
A tampering.
and a tampering.
May I speak?
Sure.
Es lo que no entiendo yo eso, porque desde los primeros 3 meses que me llegó el andamio, tenía yo el caso de muerte. Después desapareció y me pusieron temporary evidence por más de 16.
That's what I don't understand. In the last 3 months, they told me that they gave me the indictment and it showed the murder, but then it was the tampering.
All right, so let me just explain something to you. When they do an indictment, the court receives one, and the court receives the original that's signed by the foreman of the grand jury. So this is your indictment, and there are 3 counts in it. Now, sometimes what will end up happening, for some reason, when a case is indicted, instead of the higher level felony being listed first, they list the lower felony. And then people will think, oh, I'm just charged with a 3rd-degree felony tampering with evidence. But there are other counts in it. So whenever you see something, when they're bringing you over from the jail and what you're charged with, they don't list all 3 counts that are in your indictment. They'll just list one offense. And so in your case, that's why I always get confused when I see you, because in your case, on the court's docket sheet, it'll just say tampering with evidence. That's why I was looking at both of them. How can a tampering with an evidence case take 5 days or a week? But then when I go back and I remember and I look at your indictment, and 1 count, you're charged with murder, and another count, you're charged with discharging a firearm at a habitation, which means a place that's occupied and somebody's living. And then the 3rd one is tampering with the evidence. So when they indicted you, they just took 1 general case, and they, under that 1 case number, they put all 3 counts. If they wanted to, they could have said, you know what, we're going to charge him in 3 separate cases. You have 3 separate cause numbers. 1 cause number would be the murder case. 1 cause number will be the discharging at a habitation, and the other one will be tampering with evidence. But they just decided to put it all in 1 indictment. Do you understand?
Sí.
Yes,
Ahora, le pido por favor.
I ask you, please.
Por eso ya tengo más de 1 año y medio diciéndole al abogado que quiero ir a juicio.
It's been more than a year and a half that I've been telling my attorney that I want to go to trial.
Porque lo que por eso quiero ir a juicio, para que el jurado me escuche y también la juez me escuche, porque aquí no me dejan hablar cuando yo vengo.
That's why I want to go to trial, in order for the judge to listen to me, the jury to listen to me, because when I come here, nobody allows me to speak.
Y luego, para lo que me están acusando de muerte, que me están acusando que le disparé a una habitación, y lo otro, por eso quiero que me enseñen las pruebas de que tengo, porque yo sé que yo tengo mi mente limpia, que yo no hice nada. Quiero que me enseñen.
And then they're telling me that, there's the case of murder and then the discharge of a firearm. So what I want is for, to be able to see all the proof and everything that they have.
All right. So let me explain something to you. Sometimes the length of time that it takes you to go to trial is outside your attorney's control. The way I say we can't do two cases at the same time for jury trial, we came close one time. We had a jury deliberating and started another trial. But your attorney can't be in two places at the same time. And I guarantee you, Mr. Garcia, I know him. He's never been to my house for dinner, so I don't know him that way. But what I can tell you is, I know for a fact that he's been in a jury trial since your case was pending. And if he's in a jury trial somewhere else, he can't be in a jury trial here because nobody can be in two places at the same time. And then when we're in a jury trial, we can't have your trial. So then your case will get pushed back to another day. So the fact that this is your setting day is not your attorney's fault. It's not my fault. It's not the state's fault. It's just that your case is not the only case on his docket, on the state's docket, and my docket. If your case were the only case that was pending in all of the cases that I have, and I think I have over 1,000 or something, we would try your case right now. Today, I would bring a jury in, but that's not what we have. Now, with regards to your viewing the evidence, I've been a defense attorney, I've been a prosecutor. What I can tell you is sometimes people, when they're charged with a case, they don't look at their evidence objectively. They want something and they want their attorney to tell them something different than what they're seeing. Your attorney can show you the evidence, you look at it, and then you make an informed decision on whether or not you want to go to trial or whether or not you want to reach an agreement with the state. I will tell you what I tell everyone here. I've had people come to me before bench trials. I found some people not guilty. I found some people guilty. Whatever evidence is presented to me, this is a murder case. For me, I would listen to the evidence and I'll base my decision on the evidence that presented to me. I'm not going to say, oh, the state didn't prove their case, but this is a murder case. Let me find somebody guilty. For me, it's a murder case. Did the state prove their case beyond a reasonable doubt? Even on a murder case, if they didn't prove their case beyond a reasonable doubt, I'm going to find you not guilty. If they prove it beyond a reasonable doubt, I'm going to find you guilty. Do you understand?
Yes.
Now, if you want a bench trial, I can get you in here sooner. But in order for you to be entitled to have a bench trial, the state has agreed to waive the jury and you have to agree to waive the jury. So if you want a bench trial, then we can do it sooner. If you want a jury trial, the earliest I can have you in here is that December 9th date. If something falls through, the state can call your attorney, the coordinator will call your attorney and say, we have an earlier date open. Do you understand?
Yo no le estoy echando la culpa a ellos de que el juicio, ¿cómo se llama? Que se está tardando nada de eso.
I'm not blaming
Yo
them
no-
that the trial is taking long or anything.
Yo no me estoy guiando a lo que ellos me están diciendo, que me dicen que una fecha y luego otra y otra y yo estoy esperando.
I'm basing myself on what they're telling me. You know, they give me one date, they give me another date, they give me another date. You know what I mean?
The reason why is because when you are given a jury trial date, if there's a case that is older than yours, that is on the docket as well, then that case will go first. In your case, you had a co-defendant. The co-defendant decided to enter into a plea. So once he or she entered into a plea, then your case became next. Your number ends in the letter B. So the person whose number ends in the letter A goes before you.
Okay.
Y otra, no es porque no quiera ir nada, simplemente que en más de 27 meses no me lo he visto 2 veces por aquí nomás.
Well, and the thing is, not that I don't like him or anything, but in the 27 months, I've only seen him like twice.
All right, so here's the thing. Let me just tell you another thing. Sometimes defendants want to see their attorneys. They would love to see them on a daily basis because I know this is an extremely important case to you, right? But some attorneys, if they don't have any new information to give you, Their whole thing is, why am I seeing you? I don't have any information to give you. I'm going to show up and say, hey, we're waiting on this discovery. I don't have it yet. Now, I will tell you, when I was a defense attorney and I was starting out, and this is how you get burned out, I would see, if I had a client in jail, I would see them once a week. I would take the via bus, go to the jail, and I would see my clients on Saturdays and Sundays. And I would come and I would tell them, hey, I'm just letting you know that I'm still working on your case. I'm still waiting on this, because sometimes the only visitor that your client will have is their attorney. Now, I would do that. I didn't have to do that. And your attorney doesn't have to do that. If they don't have any new information to impart to you, there really is no reason for them to see you. Because at the end of the day, in the words of John Wayne, we're not here to make friends. We're just here to do a job. Right? Uh-huh. So that's where we are. Now you're saying you haven't seen something. He said he hadn't seen what the state has against him.
Nomás me enseñaron un video que tienen contra mía, que según estuve presente y es lo que he visto yo nomás. De
The
100,
only thing I've seen is a video that they showed me where I was supposed to be there. That's all I've seen.
de 100 videos que trae el investigador, nomás me han enseñado
So
uno.
let me ask you this.
The 100 videos that the investigator has, they only showed me once.
All right. So here's the thing. My question is, have you seen the police report?
No me enseñó nada.
They have not shown me anything.
Mm-hmm. All right. So, Mr. Garcia, I understand what's going on. But if you could just grab the state's file and let him read the police report.
I'll do it again, Judge. I've done it in court
I know
many
you have.
times. My investigator spent countless, a lot of hours showing him tons of video, reading him all of the reports. My investigator speaks Spanish perfectly, and that's why we have that done, so that there's no problem. It's much harder here in the court, but I'll go through it again.
All right. So they're going to go over the police reports with you again. It's going to be whatever is in the state's file, and your attorney will look at that. And after looking at that, if you change your mind about anything, just let the court know. But your court date is going to be December 9th.
Thank you, Judge.
Gracias.
Muchas gracias.
Yes, thank you very much.
De nada. That's all I know, really.
Here's a copy of
Yo tengo uno.
So this is a complicated situation for me. I mean, his charges are fairly straightforward, but apparently no such thing in his case as a quote-unquote speedy trial. This is dragging on forever, so I can see where that would be frustrating as well. But we see a lot of this. I mean, Judge says she's got, 1,000 active cases floating around her docket? That's crazy. So the question, I suppose, becomes, is the judicial system just overworked? Do we need more judges, more lawyers, more all of that? Or not in the case of this guy, because his charges were fairly straightforward, but do we just have too many laws? Are there too many ways for people to get in trouble and it's clogging up the system? I suppose these are the questions, aren't they? If you have thoughts on it, put it in the chat, but it's probably a combination of both. We probably need a more beefed up judicial system, and we probably need a lot less laws. Let's go back to Judge Simpson. He's still trying to clear out his incredibly packed courtroom.
Sir, you do realize that I'm not saying it would be successful, but you may be able to assert self-defense in this matter? I don't want to hear your comment on that. You understand that is a possibility?
Yes, sir.
All right. Do you want an opportunity to discuss that with your attorney? Because as it stands right now, I cannot accept your plea.
Okay. Yes. Yes, sir.
Want some time to do that? All right.
Yes, sir.
So let's take him back and I'll bring it back out later.
Thank you, Your Honor. Give that to Mr. Allen.
And just remind us he needs the equipment when he comes back out.
Thank you, Your Honor.
Court calls the case, People versus Deshaun Clifton.
Stephanie Canna on behalf of Mr. Clifton.
Wow. It is. Your name, sir?
Deshaun Clifton.
Thank you. You're requesting an adjournment.
Yes, sir.
Probable cause conference, May 29, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
And I'll call you like.
Court calls the case People versus Richard Johnson, the second.
Hannah Mackey on behalf of Mr. Johnson, who was to my right. Please state your name for the record.
How you doing today? Richard Johnson.
Thank you.
Your Honor, at this time, I believe we'd like to set this matter for preliminary examination and all discovery is complete as far as we are aware.
People have their witnesses available the 27th.
We can try our best, but I wanted to make sure the court was aware. Mr. Johnson has 2 other cases that are already set for exam next week. That's a short turnaround, so again, we'll try our best to get our witnesses there, but I didn't know if we wanted to put them all together.
Is there a reason they need to be all together?
There's no reason, Your Honor.
So he has 2 set next week.
Yes, Your Honor.
Preliminary examination in person will be. So will the people have their witnesses available the 27th on this case?
We'll try our best.
May 27, 2025, 9 a.m. That is before Judge Fresh Hour.
Thank you.
Bond in this matter will continue. Thank you.
Bailey, budgeting is definitely an issue across the country for sure. Yesterday, Judge Middleton was talking about Hillsdale County in Michigan, which is a nearby county to where he is, and how they only in their district attorney's office have 1 person right now handling everything because the county is only allowing so much money for DAs to be paid on their salary, the assistant DAs, and they can't find anybody to hire. And on top of that, Hillsdale County apparently has a fairly large jail, and they're renting out beds there to other counties that are overflowing. So they're bringing in a whole bunch of extra inmates into Hillsdale County to house them. So they're trying to make extra money that way, and the whole thing is just a disaster. But yeah, budget's a problem for sure. I still think we also have way, way too many laws.
Don't look at her.
Your Honor, we are waiting for him to complete his assessment for drug treatment court. So however much time the court sees fit.
See, you did that all on your own. Didn't need, she wouldn't have told you that. She would have started picking numbers. Which court is he waiting on an assessment?
14B, Your Honor.
All right, let's do it this way. Thank you, counsel, for informing me of that. That makes it easy for me. Unlike your supervising attorney, would you? June 5th, 2025, 9 a.m. Bond continue.
Thank you.
Thank you, Your Honor.
You're welcome, sir. Well, we wait a minute, because I don't. Oh, Ms. Dennis there. Okay, so let me get this guy, and then we'll get him back out. Hold on a second. I got this one? No. Or no? Okay. All right. You just tell me. I'll deal with it. Court calls the case People versus Danielle Klimola.
Andrew Childers appearing on behalf of the people, Your Honor.
And Assistant Public Defender, Sergeant really on behalf of Danielle Klimola, who's approaching. Danielle, state your name for the record, please.
Danielle Klimola.
Thank you.
Your Honor, I am handing the court a plea form as well as the advice.
We don't get these before. But never mind. Court has before it a plea form that indicates that the defendant will be pleading guilty to the charge of use of cocaine. That's a misdemeanor, 1 year misdemeanor of use of cocaine. Upon her successful plea to that charge, count 1 would be dismissed. There is the further indication that the defendant is to enter the 15th District Court sobriety court.
Your Honor, I don't know if this curiosity would bring this up. My understanding is the defendant is under sentence honor the year in jail. And there may be an ask.
That is correct.
For modifying that sentence.
Day?
Whenever the court, I don't know how the court would like for us to address it, we
I
can
wouldn't,
come.
but go ahead.
We can submit a motion to that effect.
You have to present a motion
Absolutely.
for that.
And I guess I'll put on the record right now, people have no objection to that and would be fine with the defendant's entry to sobriety care program. She's been screened.
All right. Okay, this is the court's full understanding of the agreement. Is that correct?
That is our understanding as well. Yes, Your Honor.
May I have her sworn?
Raise your right hand. You solemnly swear the testimony you must give to be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name.
Danielle Claymore.
All right. Mary, it is this court's understanding that you are going to be pleading guilty to the charge of use of cocaine. That is a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. Do you understand that?
I do.
Understanding, and I also should advise you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo in 15th District Court. You understand that?
Yes, I do.
Still wish to plead guilty?
I do.
And to that charge, how do you plead?
I plead guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind?
Yes.
You signed an advice of rights form, is that correct?
Yes, I did.
Any question regarding those rights?
No.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on the form.
Yes. Yes,
You understand you're giving up your right to appeal of right.
I do.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Anybody threaten you or coerce you?
No.
Doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe that you're indeed guilty?
Yes.
March 18, 2025, a location on South State Street, City of Ann Arbor, Washtenaw County, State of Michigan. Did you have cocaine in your possession?
I did, yes.
Had you used it?
Yes,
Did you know what you were using was cocaine?
I did.
Counsel, have I complied with the court?
Defense is satisfied as well, Judge.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed.
Thank you, Your Honor.
Pre-sentence investigation and report is ordered at 15th District Court. Probation sentencing will be
June 3rd at 10 a.m. with Judge Allen.
June 3rd, 2025, 10 a.m. Judge Valvo.
This was also in the email from Ms. Johns from the 15th District Court about possibly setting this on Friday. I don't know if the court gets those sentencing dates for 15th on Fridays. I'm sure they could also modify it. Judge Valvo could also set it on a different day. I know the court only gets so many days.
Yeah, I don't have that.
I only have June 3rd.
So we'll just set it down.
Yeah, okay, I'll just set it June.
And Your Honor, it's actually at 9 a.m.
Oh, it's at 9 a.m. before Judge Valvo. All right. Okay. Thank you.
Almost done. Thank you so much, Your Honor.
Court does call the case People versus Elijah Kraft.
And is in on behalf of the people, Your Honor.
She's back.
Good morning, Your Honor.
They gave
Student,
you a bunch of cases, didn't they?
yes,
Did they?
not a bunch, a fair amount.
Not a bunch? Who gave them to you? Did she give them to you?
I cannot confirm or deny, but I was assigned. I'm kidding.
Did Acting really give you all these cases? Did she say when she gave them to you, I don't want to do anything today?
No.
Oh, she didn't say that? Okay, I was just checking. All right, go ahead, counsel.
Student attorney Andra Sabri on behalf of Mr. Elijah Kraft, who is present in person with me today, Your Honor. If you could please state your name for the record.
Elijah Kraft.
Thank you, sir.
Your Honor, we respectfully request that these matters be set for a preliminary examination.
All right. And on both of these matters, all your discovery is complete?
To my knowledge.
And would the people have their witnesses available the 27th?
We'll do our best, Your Honor.
Preliminary examination, May 27th, 2025, 9 a.m. That is before Judge Washington.
Thank you, Your Honor.
Right? Bond will continue. Thank you, sir. Here. Get to it. Court calls the cases of the people versus Dale Miller, 3 cases.
And Maggie on behalf of Mr. Miller, who is approaching. Please state your name for the record.
Dale Miller.
Your Honor, we recently have received a competency report, and we stipulate to findings of Mr. Miller being incompetent but restorable.
They've determined that he's incompetent to stand trial at this time, but likely to obtain competency through treatment. Is that correct?
Yes, Your Honor.
All right. All right, I have reviewed that report. I will sign off on those orders. I'll set a competency review hearing. I need 90.
90 days would be August 14th.
August 14, 2025, 9 a.m. Defendant's bond will continue.
Right. Thank you, Your Honor.
Thank you. Court does call the case of the people versus Martez Dalton.
Anna Mackey on behalf of Mr. Dalton, who is, I believe he's riding a bus right now to court, Your Honor. The last we've heard, he was in downtown Ann Arbor 20 minutes ago. It's a slow bus.
No, he came from Detroit. Let him know he came from Detroit.
The bus has been driving from Detroit, Your Honor. Maybe it ran out of gas.
You ran out of what?
He's coming. The bus is coming.
How do I know he's on a bus?
I spoke to him, Your Honor.
Huh?
I spoke to him and he said he was on the bus.
So what do you want me to do? Bench warrant him?
No, Your
And
Honor.
we can go get him?
If you could please pass this matter for a few.
A few. Okay, so hold on. I went through this almost exact same thing with Cannon. And yes, I know, they had pictures all along of him on his bus ride. It was just, it was
So
like
it's a
trees.
common
It was
thing?
video. It was just trees going by a window on a bus. I don't know if it was on a bus. But at least they had gave me pictures. Not you, nothing.
I'll provide photos, Your Honor, in a minute. It's clearly a common problem with buses. If Stephanie had the same issue with her.
Okay, Mackie, when's the last time you got on a bus?
For school, Your Honor. We ride a bus from the parking lot to class. It's like a mile walk.
When's the last time you got on a bus for travel around the city or?
New York. In New York. Subway, that's even better. Subway.
A subway is different than a bus.
Okay, I've never been on a bus, Your Honor.
I didn't think so. Okay, thank you. I'll pass it.
Thank you, Your Honor.
I've never been on a bus. I know. Don't know why you're trying to fight it. Just say I've never been on a bus. She doesn't even know if it's a slow bus. Court does call the case. People versus Rahman Mohammed.
My client is not on the bus.
Are you calling him, Mackie?
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Rahman Mohammed. Mr. Mohammed, please state your name.
Rahman Mohammed. Thank you.
Your Honor, today's date and time set for probable cause conference. We are respectfully requesting that this matter be set for preliminary examination. Also, we'd like to address bond at the.
All right. All discovery is complete.
As far as we know, yeah.
People have their witnesses available the 27th.
We will try our best, Your Honor. I did want to let council know Mr. Muhammad has a new warrant in as of just a few days ago. Office received for a fight in the jail apparently, so I'll have that reviewed this month.
Preliminary examination, May 27th, 2025.
Thank you,
9
Honor.
AM, that's before Judge Freshour.
Thank you, Honor. As to bond.
Yes.
Your Honor, my client is respectfully requesting that the court allow him a personal recognizance bond. He does have a place to stay. He would stay with his father, Kushir Muhammad. That would be in Banner Street in Detroit, Michigan. He's asking if the court feels that it's necessary, he would agree to wear a tether to ensure that he returns to court.
Response?
Your Honor, I think the underlying case, or the case that was set for exam is a bit older, if I'm not mistaken. I'm not sure how many in custody. I am concerned that while he's been in custody, potentially accumulating assaults and offenses, but I will leave that in discretion of the court. I would request that if he is released, that he is testing, given the nature of this.
My client will agree to test.
Did he come into custody?
A traffic stop. Your Honor, my client tells me that it was a traffic stop.
Oh, Your Honor, maybe approach, please, very quickly.
Approach.
Okie dokie, well, they are muted. Let's go back to Judge Boyd.
Court is calling 2025 CR 003649, State versus David Wayne Huff. Can I have parties announce?
Matthew Finch for David Huff, Your Honor, ready.
And are you Mr. Huff?
Yes, ma'am.
Counsel, have you received all discovery?
I have, Your Honor.
Did you review it with your client?
We have.
Court will find that the state is in compliance with discovery. Mr. Huff, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do waive, Your Honor.
State, are you proceeding on the indictment as presented?
Yes.
All right. Did you review the court's admonishments with your attorney? Did you understand it and sign it in all the appropriate places? Did you understand you're charged with possession of a controlled substance, penalty group 1, less than 1 gram, within 1,000 feet of a playground, and that makes it a third-degree felony? Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Okay.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Huff, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 6 years in the prison. The state recommends community supervision. They will take in consideration 2025 PF 06925. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 6 years. Did you understand that's a recommendation from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charge, how do you plea?
No contest.
State any evidence.
State offers exhibit 1 and attachments, Judge. We've reviewed those, Your Honor. We have no objections.
State, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find that there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor. We waive PSI today.
Anything you wish to say on behalf of your client?
Your Honor, my client is motivated. He's accepted responsibility today. He's asking of the court to follow this plea bargain. We would ask that you sentence him accordingly and follow our recommendations to the court as well.
All right, so how long have you been using?
About 10 years.
All right, why did you start? What happened in your life?
My mom, my dad, and my stepdad was killed in the car wreck.
I'm sorry to hear that.
Kind of messed me up, but
So are you, if you were tested today, what would the results be? All right, positive for what? And what else? All right, so here's the thing, where you're starting at now today, it's the court's hope that this probation, you'll improve and you'll get clean and sober and you stay clean and sober. So do you have any support system?
yes, ma'am. They want me to go to treatment.
Right, so I mean, do you have, who do you still with?
I got my own house. I stay in Asheville Road. But,
Okay, so do you live by yourself?
Yes, ma'am.
Do you have any children?
No, I got 2 kids, but they live in West Texas.
And what are their ages?
My son's 24 and my daughter's 18.
All right, do you have any grandchildren?
No, yeah.
Okay, are you working at all?
Yes, ma'am.
What do you do?
I work for, right now I work for People Ready.
I'm sorry, what?
For People Ready as an electrician.
Okay.
So.
All right. This is what the court will do. The court will sentence you to 6 years in the prison, suspended and probated for 6 years. There's to be no contact with Veronica Renee, Renee Trevino. There's to be proof of employment within 30 days. No employment as a home health care provider or with minors. Regular reporting by Zoom or in person. Regular random UAs. Field visits 1 time per month until further notice. There's going to be 200 hours of community service restitution. 120 sober meetings in 120 days. A referral to felony drug court. A TAP evaluation. Out of custody. Follow TAP recommendations. Probation, is there anything else he needs? And I'm sorry, taking consideration 2025 PF 06925.
Judge, may I approach?
Yes. Is there anything else you need from the court in order to be successful?
No, ma'am, I appreciate it.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand? All right. In this court, to be successful on probation, communication is key. So if there's an issue, talk to your probation officer. If you feel as though they're not addressing it, you can always come back to court. And nobody can help you, and we can't help you with your drug addiction if you don't want to help yourself. Now, I've ordered that you have a TAP evaluation out of custody. They're going to give you a date for that. If you miss that date, what's going to end up happening is a motion to revoke is going to be filed. You're going to be taken into custody. Either you'll make bond or you won't make bond, and I'll hear that motion to revoke. So if you need to get an appointment booklet, get an appointment booklet and put your dates down. You understand? And when you leave here today, other than following their instructions, you need to go to a sober support meeting. Those are the NA meetings, so you can get your life back on track. Because if you continue to use, only two things going to happen. Either you're going to end up in prison, right? And you're going to lose everything. You're going to lose your house. You're going to lose even more time with your children. Or either somebody's going to have to come down and identify your body. You understand? All right, good luck to you.
Thank you, Your Honor. May we
Thank
excuse?
you. Yes. Just have him remain in custody to speak with probation.
So I'm going to switch this back to Judge Simpson for the last few minutes of the day here at the Courtroom Files Live. But question for all of you. Would you let me know in the chat if you got, if you're subscribed for notifications, if you got the notification for today's show? Because I'm seeing what I would expect to see on Rumble and X today, but I'm not seeing what I would expect on YouTube. Our amount of views is about half of what we normally see. And as I'm looking around at different feeds, not just Courtroom feeds, but other feeds, it seems like everybody is way off. Like, there's a feed from Fox News Live, for example, which should be in the thousands that has like 300 viewers. So I don't know if YouTube's notification system is broken or if the data that they're reporting is wrong, but something's definitely up, and I'm just trying to figure out what it is. And there's definitely something up, because if I look at the live data for the channel for our videos that aren't live, it's through the roof right now. So people are tuning in here at the Courtroom Files. I'm just not getting it live, and I'm just curious. Either you're all really there and I'm just not seeing the data because it's not reporting, or you're not getting notified. So just let me know if you would. Ashley, not for today. Okay, so you didn't get a notification. That's interesting. There was one yesterday. Yeah, well, that doesn't count for today, so maybe that's it. Maybe it's broken, because nobody who's doing live right now is getting the numbers they should be getting, so it's really weird. Anyways, thank you. Just trying to figure it out. Let's get back to Judge Simpson, and we'll close out the day with him.
Michael Gaddy, Assistant Public Defender, on behalf of Ms. Pressey, who's approaching Judge. What's your name?
Danielle Pressey.
Requesting an adjournment.
Yes, Your Honor. There's a lot of discovery to go through.
May 29, 2025, 9 a.m. Bond continued.
If I could be heard on bond, Judge.
You may.
Thank you. Judge, I did have a chance to talk with Ms. Pressey. She is here before the court with a bond of I think it's set at 150,000 cash. This is a situation where she has absolutely no criminal history the last 13 years or so. She does have an old OWI matter from 2012. That's all I could find on her CCH. She resides in the Metro Detroit area in Oxford or Lapeer. She owns a business, a brick and mortar business, a nail salon. She's not a flight risk in any way. She cares for her disabled mother. She is, like I said, gainfully employed. She owns a business, a nail salon that she is the proprietor of. She is. We'd ask the court to consider some kind of a reduction in bond, hopefully a personal bond. Like if she would avail herself of any both a scram and a GPS tether if the court thought that was beneficial to ensure both her presence and that she's not anywhere that she should not be. She has, as I said, work, family responsibilities, and have to care for disabled mother.
Response.
The facts of this case involve a defendant traveling around 60 miles an hour. It's on Marks Road, which I believe is 45, but and it's probably 45 would be my guess. 60 miles an hour with now candidly the BAC was 0.038, but there was also an 200 nanograms per milliliter of amphetamine, as well as THC, 2.7 nanograms of THC in her system. The victim is tragically the defendant's son, I believe was 7 at the time. He was improperly belted in the rear seat and killed in the accident. The vehicle crashed into a tree. Based on those facts and circumstances, I don't believe that the bond is improperly set. I believe that the facts of this case are awfully tragic, but I am concerned about the defendant's potential conduct while out. This matter pending given the seriousness.
Your Honor, if I might, this is a very serious situation, very tragic. There was, the allegations of the purported Adderall, I believe, was a prescribed drug. As Mr. Childers stated, it was a 0.038 of what was the reported drug or alcohol. This was, like I said, this was a situation where I don't think she comported herself. This accident happened several months ago. She's comported a bit back in December, I believe. She's comported herself properly since then. She'll continue to do so. As I said, she's not a flight risk in any way. And she does have responsibilities while we, there's a lot of information to look at here. And I believe this is a matter that is going to be litigated pretty heavily. So I'd ask the court to reduce the bond.
Motion for bond reduction is denied. The court does consider the defendant a risk to public safety. And so her bond will continue. Thank you.
Thank you. Your Honor, if we did put together a written motion, would the people waive notice on that?
No, I'll waive notice as long as you don't give it to me at the end of the day on Wednesday.
No, I don't do that. Okay.
Yeah, as long as I have a fair amount of time to respond to today.
Court consider hearing it early as well, Judge?
It will. When we receive the motion, Ms. Wagner will be more than happy to give you a date to hear it.
Thank you, Judge.
Court does call the case of the people versus Jordan Dave.
I'm sorry, Judge. I didn't catch the adjourned date. My fault.
29.
Thank you. Right.
Jordan Davis.
Oh, that's you. I'm sorry. Okay, there.
And then on behalf of the people around. And Mackie, on behalf of Mr. Davis, who's approaching. Please state your name for the record.
Jordan Davis.
Okay. Your Honor, at this time,
No, I'll wait.
we'd like to set this matter for a preliminary examination.
All discovery is complete.
As far as we're aware.
People have their witnesses available to 27.
Yes, Your Honor.
Preliminary examination in person, May 27th, 2025, 9 a.m. That's before Judge Fresh Hour.
Thank you, Your Honor.
Thank you.
Bond will continue. Thank you.
Okie dokie, we've reached that point in the day where it's time for me to tell you all goodbye. I am right this very moment putting a link in the chat. This should be the next video you watch if you want to keep watching stuff, at least in my opinion. This is a video that I put up yesterday from Judge Simpson's court, and it involved a lady who was accusing the defendant of violating his probation because she had a no contact order that was part of his conditions, and she claimed that he was constantly trying to make contact with her. This hearing is one of the more interesting, for lack of a better way to put it, ones that I've seen in a long time. It's about an hour video, so you have to commit to it a little bit. And admittedly, it starts out just a little bit slow, but by the time you get to the end of it, there's a payoff to it. It's quite entertaining, I think. Bailey, I know you watched it yesterday. You can testify in the chat. I think it's a video worth watching. So if you want the next place to go in your YouTube experience, go there. That would be my recommendation. Otherwise, I'm going to let y'all go for today. Go have yourselves a great Thursday. We'll be back, of course, tomorrow, 10 a.m. Eastern, 7 a.m. Pacific. I hope y'all had fun today. We had more laughs than usual, so that's always nice. But we'll see you again tomorrow. Take care. God bless.